I'm speaking with mediator Bill Downs today, somebody who's been in the mediation business about as long as almost anyone has for the state of Utah. And so I'm very happy to have him here with us today to share a little bit about his experiences and what he would share with those contemplating mediation for their divorce or other domestic relations kind of case. So Bill, before we get started, would you please give them your name and contact information for those that would like to
Sure.
contact you?
Sure. Again, my name is Bill Downs. I have a website at Downs Mediation, which will have my address and phone number, but it's 801-531-7400.
And it's Downs, D-O-W-N-E-S.
Correct.
So Downs Mediation with an E.com.
.com.
All right. So tell us about what brought you to become a mediator or to do mediation work.
You know, that was back in 1990. I had tired of litigating cases, was looking for a better way to help people through this process. So in 1990, I was trained as a mediator and have worked for the last 24 years in this profession.
Now, 1990 was really when mediation had been around as a concept, but was really kind of coming into its own just about that same time.
Right, and really over the between 1990 and 2000, a lot of our work was simply developing the profession, creating rules, and really promoting them among members of the bar. And then about 2005 or so, I think it was fully endorsed by the court, and now of course it's mandatory in all domestic relation cases.
So why don't we start with this then? What would you recommend people do to make the most of their mediations? And in the course of talking about that, like how they prepare or how they go about it, maybe we can talk about your approach, your specific approach,
Sure.
your philosophy, how it might differ from others, and why you choose to do what you do.
Well, let's talk about why someone would mediate initially. When you come to mediation, in my view, when you come without your lawyers, and again, you have a choice to come with your lawyers to mediation or without your lawyers to mediation. And that's a choice people have to make. They feel the need to have a lawyer at their side during the process. But if you choose to come without your lawyers, you're essentially taking on more of the responsibility of reaching an agreement that's going to be acceptable to you and your spouse. What the mediator's role is to facilitate your negotiations, to help you be successful in your negotiations with your spouse. But the mediator can't give you legal advice and can't strategize with you about what offers you should accept and what offers you should reject. So I always like to remind people when they come to mediation without their lawyers, if the mediator happens to be a lawyer, the mediator can't act in that capacity, and it's up to the parties again to think about what might be acceptable to both parties. So again, I think you have to choose, do you come with your lawyers or without your lawyers? If you come without your lawyers, you're of course free and encouraged to consult a lawyer throughout the process, before the first session, after the first session, so you feel like you're fully advised as to your legal rights and responsibilities.
So that gives you an opportunity. In other words, would you ever advise people to come without lawyers, say, you know what, it looks like we've reached a really good agreement, let's not wait. Let's not bounce this off any other attorneys. Let's just sign it right there.
Well, what I always encourage people to do, again, I don't think divorce work is rocket science. We're going to talk about sharing time with your children. We're going to talk about child support, fairly dividing the assets, and alimony. Alimony tends to be the more challenging issue in my work as a mediator. But many people can reach agreement without seeing their lawyer because their sense of fairness will be congruent with whatever agreement they reach. Other people just feel the need to check things out with their lawyers. So I work with people who choose not to see lawyers. I work with people that choose to see lawyers. And again, in mediation, the primary concept is self-determination. People get to choose how they use the system. And again, I'm not going to second guess. Ethically, I always will encourage people to see an attorney, but if they choose not to, I don't take exception with that choice.
Right. And that's important. You make a key distinction there. It's not that there's any one right way to do it. I would just chime in that sometimes a mediation that you feel good about and you sign without having reviewed with an attorney can overlook something that innocently,
Yes.
and I would think you would agree with that. So it's not a matter of employing lawyers. I am a lawyer. I'm not telling you to do that for my sake. It's just that sometimes because you came without lawyers, didn't get any legal advice, couldn't get any legal advice, if it's a good deal, it will still be a good deal after you
Exactly.
speak with a lawyer you trust. It's not a matter of being able to have buyer's remorse or second guess, but just remember, once it's signed, it's binding, almost always. And if you haven't had an attorney to help you correct a mistake or add something in that you should have, could have, and would have included if you'd known how important it was.
Exactly. We always, and most lawyers will consult with a client for an hour or two, charge a reasonable fee, and we always encourage people to do that because whatever agreement is reached, I want it to be durable and long-lasting. I would rather have people see an attorney than come back in a year or two and regret the decision they've made.
And you can't make it durable and long-lasting if you see a gaping hole in it, because that would be crossing the ethical
Well,
lines.
I will let them, we have a checklist of all the issues people have to address. We will have addressed all the issues, but at the same time, there's some variation as to what people could agree to. And often when people go through the divorcing process, they're anxious to get completion and they want to move through it quickly. And again, I think the time is well spent, spending an hour or two with an attorney to be certain that whatever decision you make, if you choose not to pursue something you're entitled to, that you have an appreciation that you were entitled to it before you chose to waive that right.
Now, I have used your services as a mediator many times before, and compared to others, I know that you ask for quite a bit of information up front. I happen to like it. Others may wonder what it's about. What kind of information, and we're talking about preparation, what information do you ask people to provide you in advance, and why do you do that?
Well, primarily financial information. I want people to bring all the documents that support their financial information, which could be 401k statements, brokerage statements, credit card statements. I want people to see things in black and white before they make a final decision. So if you came to mediation and didn't have, let's say, your estimated pension payment when you're 65, that may be an important factor in the negotiation. So I don't want people guessing. I want people to actually be able to look at the document to support all the financial information.
What other information besides financial information do you ask for?
That's primarily it, because if people bring pay stubs, tax returns, bank documents, 401k statements, that will help us get through most of the financial decisions. In the area of parenting, really, I don't think there are any documents that are terribly useful in the mediation.
But you also have some documents you have that you don't ask people to bring documents, you'll give them a fill-in-the-blank form.
Right.
What kind of information do you
Sure.
solicit from people to get to know them better?
Great question. We have people do budgets because many of us hate budgets. Very few of us can maintain a budget. But when you think about living apart and meeting your monthly expenses, it's important to be able to set that down, because that's going to be the foundation upon which we have the alimony or spousal support conversation is, what do you need to meet your expenses when living apart? So we want people to think through what's their rent going to be, utilities, food, and so forth, so they have good numbers upon which to base spousal support.
A lot of people, and this came as a surprise to me because fortunately it hasn't been a concern in my life, my personal life, is, well, I'm okay with going to court because it's a secure building, there's a sheriff's deputy or bailiff in the courtroom, but now I have to go meet across a table with my spouse. My spouse is abusive, whether it be physically or emotionally. I can't focus one way or the other, either because I'm afraid I'm going to get hit or just because I'm tired of being berated. Right. What do you say to people that are concerned about that in going to mediation face to face?
Well, I'm glad you asked the question, because that's a terribly important topic. And I do have people fill out forms prior to the mediation that do address people's safety and comfort level in being in a mediation process. And we're going to ask about what are called protective orders. Is there a limitation on you being in the same geographic location with your spouse? So I am quite concerned about people's level of comfort. There are a couple ways to deal with it. One is we do mediation in separate rooms where the spouses are separated and will arrive, let's say, 15 or 20 minutes apart, so they won't see one another. We also have people bring their lawyers with you in the highly conflicted cases so that there's a sense of safety with the lawyers present, helping them engage and interact with their spouse. But if you have safety concerns and you feel like you can't think clearly in your spouse's presence, we want to set up the mediation in such a fashion that we address that. It could be we do it via Skype or by phone. There are other ways to deal with the safety and protection. And if there are safety or protection concerns, it's likely we will not meet together at all, but have people separate for the entire mediation.
Even if people don't have concerns about any kind of domestic violence or tension by sitting across from each other, oftentimes I know people will meet in different rooms. You've done that. Other mediators will do that. Can you tell us a little bit about what the relative benefits and detriments are of having the mediator go back and forth between rooms where the parties are either by themselves or with their lawyers, but not meeting all together with you?
Sure. In most mediations, when I meet with people without their lawyers, we tend to more often than not spend that time together under the theory that it's about communication, it's about talking. Because again, this is the parties' negotiation. I'm there to help them be successful in their negotiation. So ideally, I like to work with people in the same room. However, in a highly conflicted case, sometimes the negotiation deteriorates, so we find people can work more effectively letting me take the offers back and forth and then being in separate rooms. If people come to mediation with their lawyers, we generally spend the first 10 or 15 minutes in the same room to get me educated about what the issues are and some of the background facts. Then we tend to work entirely apart thereafter, because that gives the clients a chance to talk privately with their lawyers, strategize with their lawyers, think about what offers to make, which really is best done while working apart.
What, any downsides to that? I mean, other than the obvious one that it's going to take more time because it's got to be meet with one party, relay it to the other, but is there any other?
Clearly, again, the better people are able to do this in the same room, I think the more creative settlements can be reached. However, I think we sort of err on the notion that I think people are best served meeting with their lawyers privately if they bring their lawyers. Otherwise, it's hard to take advantage of the lawyer's presence. And of course, the lawyer will want to have confidential communications with the client, so it's best we do that at separate
It is
rooms.
nice to be able, I mean, as the attorney in a situation like that, to sit quietly, privately, away from anyone else, where I can hear the mediator come into the room and say, here's the concern, here's the offer, here's the proposal, and then I can spitball with my client, and we might go, yes, that's a good idea, go tell, wait a minute, actually, and we can do all that, whereas
Right.
we wouldn't do that around the table, because then they go, aha, I see that you hesitated there, I smell blood in the water, or something like that.
Yeah.
So it is useful. So for people that might wonder they think that's kind of odd, they have in their minds, I know that a lot of people think we're going to sit around a circular table and there's going to be a big pad of paper, because all the mediators use the same stock photo, the big easel, and they've got the Sharpie or something like that. Well, Bill does have an easel, but he does have a table. But not everybody's going to work that way.
Correct.
And so you may be comforted to hear that, you may be slightly disappointed, but it's good for you to understand what's behind that. It's not just convention, it's just you find that it's quite useful. It's not the only way that you'll do it.
Right. Again, I try to, when we commence the mediation, talk about what process will work best. Do we start together? Do we start apart? And just try to see what people are most comfortable with. Though I do encourage as much time together as possible if people are comfortable with that.
What are the things, for the sake of customer service, that you wish mediation participants would not do to make you more effective and less expensive? What are the things that people do in spite of themselves, or maybe not realize they're doing, that you just think, if I could just tell them in advance? You know the story about
Sure.
Baron Hilton, where when he turned 85, he said, anything you'd like to say? And he turned to the camera and said, please remember to put the shower curtain inside the tub. That's what he had to say. So what would you tell people to say, you're really self-destructing and wasting time and money when you do these things?
Right. You know, over time, I believe I've sort of streamlined my process, made it more efficient. I think what I would like to say is that I'm confident most cases can be settled if people simply think about what's in their children's best interest and how to fairly divide the financial assets. This is not, I think in this work, the hard part of the case is the emotional piece. I think people should see a therapist along the way to help them complete the emotional piece of their divorce. But I think often the emotional side overcomes the actual financial decisions they have to make or the decisions around the kids. And if they simply would think about the kids' best interest and then maybe work with a therapist to help them in their adjustment to living as a single person, I think most cases will settle. Most cases do settle. So the sooner you can get into mediation and begin to have productive conversations, the better.
When people don't prepare, do you have a kind of a general idea as to how much longer that it takes, or how much worse the
Sure.
outcome is?
Sure. I don't know. I'm not a great believer in people doing a lot of preparation before the mediations. I think I can help them be more effective in their negotiations. I can get people right to the heart of the issue rather than going down a road that's not productive. People often find themselves arguing over things that really don't matter. So if I can sort of get people to focus on really what is important, get those things settled. So I think working with certainly preparing, having productive conversation with your spouse ahead of time is great. Like working out who gets the couch, who gets the TV. That's always good to get out of the way early. But if it becomes argumentative, I'd rather them save that for the mediation. Like I can help them be more productive in their negotiations.
That's pleasantly surprising. I wouldn't have considered that, but it makes perfect sense now that I hear you say it. Well, I appreciate you taking the time to tell us about these things. Before we go, for those that would like to give you a call and use you as the mediator, could you give them your contact information one more time, please?
Sure. Again, my phone number is 801-531-7400, and I'm in Sugar House.
Thank you very much.
My pleasure.